Hello, everybody, and welcome to the last of Fasken's Labor, Employment, and Human Rights Group Year in Review seminars. Today, we're here to talk about collective bargaining. My name is Ian Campbell. I'm a partner in Fasken's Labor Employment Group here in the Toronto office, and I'm joined by my colleagues, Karine Fournier from our Montreal office and Andrew Dixon from our Calgary office. Over the course of the next 90 minutes, we're going to try and give you a flavor for what's going on at bargaining tables across the country. We're going to try and highlight some key trends that we've been seeing over the past year. We're going to talk to you about some case studies, some things that have been in the news. We're going to talk to you a little bit about legislative and policy developments and trends that we think could be coming to a bargaining table near you, if not already, then sometime very soon. And then we're going to wrap it up by trying to preview to the extent we can in this ever-changing world about what you can expect to see through the 2026 as we move into 2026. Before we do that and get into the actual substance, though, I wanted to take care of a number of administrative items and make sure that we're sorted here. So let me start off by just saying that you have access to the handouts and the slides that you'll be seeing through the course of this presentation. They can be downloaded using the handout tab. CPD, for those of you interested in getting CPD, there's links and QR codes. It'll be the second last slide at the end of the deck. You'll be able to do that in order to get accreditation for the various organizations that you may be a member of. We have a survey at the survey tab at the bottom. We would strongly encourage everybody, if you have a chance to fill it out, it'll only take you a minute. We really take your feedback seriously and we use it to try and make our programs better and more relevant in the future. So if you would take a moment to fill that out, we'd very much appreciate it. We're going to try and leave some time at the end for questions. Hopefully we can answer them, or at least try. And so if you would feel free to send in questions at any point during the presentation, and we'll try and deal with those that we have time for at the end. If you require closed captioning, there's a closed captioning available by clicking the CC button at the bottom of the video screen. And should you ever need technical support, please click on the technical support tab. Let me check my notes. I think that's all the administrative stuff. So without further ado, why don't we dive right in? So collective bargaining trends and developments. What are we seeing? So when we were sitting here giving you this update about 12 months ago, we were talking about how inflation is coming down, and we're hoping that that was going to turn into a return to the good old days where you were able to get more cost-effective settlements and the cost of getting a deal was a little bit lower. We haven't seen that, or at least not nearly to the same degree as we had expected. Inflation has been tamed, but wage growth and significant wage increases persist. Now, that's perhaps not surprising. Any economist will tell you, once inflation has taken its effect, the inflationary increase is built into the price of all the goods and services that we need and use to live our lives. And so with that increase is already built into the price of everything, cost of living remains high. And so therefore, we're going to continue to want to see upward pressure in the unionized sector on wages. So we're going to go through and give you the latest on that, but one of the many challenges that people are facing now is this gap between employee expectations driven by the cost of living and various obvious concerns about economic uncertainty, as contrasted with an employer's ability to pay. And in that regard, we're facing so many different challenges, and we're going to talk about those more in just a moment. But what we're seeing now is, unlike in the pandemic where everything was on the rise, and despite the fact inflation was high, many businesses were doing quite well. Now we're seeing an effect where we're still seeing the upward pressure on the wage rates, but we're seeing many more employers having difficulty, and that's creating a gap that is something that we need to pay attention with. So bargaining has never been easy, and it's certainly not easy now. And this is one of the main challenges that people are having to tackle, both in the latter part of 2025, and we see this continuing into 2026 as well. So we avoided including any words in the slide deck about the president of the country to the south and/or tariffs, but it is the elephant in the room. There's been a lot that's happened over the last 12 months, and it's had a significant impact on the Canadian economy. It feels like at times we don't know what's going to come the next day, and one news cycle begets a story that's even crazier than the last. And so, over the course of the last 10 or 11 months, we've been faced, I guess since April, really, differing tariffs and all sorts of changes, the likes of which we haven't seen in decades, if ever before. And so how has that had an effect on the bargaining table? Well, I think more broadly, our experience is that when everything first came in, everyone was in a state of shock. They were almost waiting for the nightmare to end, and they were waiting for a return to normalcy. And people just sort of did what they could to hunker down and sort of make it through in the hopes that things would be better, a deal would be reached, tariffs would be lifted, or there'd be other changes that would allow for more of a return to the status quo. But we're now at a stage where we're sort of past that. And people are beginning to realize that this may be, at least for the next little bit, the new norm. And people are having to make very difficult decisions. Now, it's very sector specific. There are some sectors that are hitting it out of the park and doing very, very well. But there are many others, including many upon which the Canadian economy has relied on for decades, that are facing existential threats. And we're at a little bit of a pivot point, I believe. And so what we feel out there is uncertainty. We're seeing job losses that are really only starting to hit in the last few months. As much or as recently as earlier this week, we've seen large layoffs at major industrial concerns like Algoma. We're seeing layoff notices from large tech and telecom companies across the economic spectrum. Everybody seems to be sort of taking the steps they feel they need to position themselves for moving forward. And so what that means in the context of bargaining is that we're seeing a renewed focus on things like job security, concerns about technological change, and concerns about outsourcing, contracting out, or privatization, depending on the sector we're in. And this is all driven by the current economic state that we find ourselves in and the many challenges it presents. And so as we go through the seminar today, we're going to try and highlight these issues in more detail and talk to you in a little bit practical terms about what we're seeing and how this has been playing out in a bunch of different contexts. Other trend is replacement worker bans. We've had a ban in Quebec for decades, since the late 1970s. We've seen it introduced in many provincial jurisdictions in recent years. In June of 2025, we saw the introduction of a replacement worker ban, very broad, and the federal sector. And what we're starting to see in practice is this is having a material effect on the dynamics of bargaining and leverage at the bargaining table. When employers don't have the option to use other sources of labor to at least maintain certain essential parts of their business, it's creating concerns about contingency planning. It's creating concerns about protecting assets, protecting key infrastructure, and it's creating new and different issues about how we go about maintaining certain essential services. And so as we go through today, you'll see a theme where these tensions are sort of highlighted in a couple of different contexts. So with that, by way of an introduction, I'm now going to turn it over to Andrew, who's going to take you through some of the statistical details, and I'm going to try not to mess up his screen and let him control the slides. Sorry about that, Andrew, and talk about wage settlements.
No problem. Thank you very much, Ian, and thank you everyone for joining us today. So why don't we take a little bit of a look through the numbers here, and as Ian provided in his introduction, they're still high. We've seen wages remain stubbornly high, at least compared to the past, in this last year. Overall, when we look at the specific numbers across all sectors and across the country, the average annual wage increase for the duration of a collective agreement is 3.9% per year. So we're getting close to 4%. And that could be compared with last year, where we were looking at numbers around 3.5%, 3.4. And one of the interesting things is we're seeing a disparity between the numbers in the public and private sectors. So, the private sectors are catching up a little bit more to some of the effects of inflation, and we're seeing a lot of increased pressure on private sector employers to increase wages coming out of the pandemic and coming out of the increases to inflation. And one of the things we'll see when we look a little bit closer here is that there still is a trend to have front-end loaded wage increases. There's a big drive for unions to push employers to try to help their members catch up on what they perceive as loss or a big discrepancy in the difference in wages over the previous 3-4 years. And this is still the number one tool or the hammer that seems to be getting a lot of deals done when we talk about how we're going to structure wages and collective bargaining. But on the flip side, we're also seeing a reduced prevalence of COLA provisions in the private sector. So last year we thought, is this a return to COLA? We talked a little bit about how some unions were putting forward COLA proposals that we hadn't seen since the 80s and 90s. That seems to have fallen off, and that likely has fallen off due to the fact that inflation has come, at least for the time being, largely under control. So the focus now is about catching up, providing some sort of increase for the near term as well as over the course of the CBA. Now, here are some more specifics on Canada-wide data. And the first thing I want to note when we look at this is we're a bit hindered by the data that we're able to collect right now. So one of the interesting things that happened this year is that in June, the ESDC, the federal government, stopped collecting new agreements and stopped creating new stats for wage settlements. There was some complaints or some issues coming up about whether or not the data was correct. And so the federal government took it down, and they've promised to put it back up once they've sorted through some issues to make it more usable, to provide more information. But at this point, we don't have that. And so what we're only looking at here is the numbers for certain employers and certain segments for half a year. So the numbers are going to be, I think, representative of what we're seeing. And I know when talking with Ian and Karine, they're representative of what we're seeing, although they're not the best numbers that we've been able to have in past years. But as you can see, in Canada in 2025 and the collective agreements that were reflected in the federal database, we're looking at an annual percentage increase of 3.9, which you can see highlighted there. But a first-year average of 5.8, which is quite high and much higher than what we've seen in the past. As you can see, last year was 4.8, and then we were down in 3s, 2, 1s. So this is a significant increase, no matter how you slice it in wages and in first-year increases. And so at least what we could see is this clear trend is continuing, and we expect it to continue through 2026 at least.
And Andrew, if I could jump in there, before everybody falls off their chair and starts looking at these numbers and, oh my God, we're going to go out of business. These stats are to some degree skewed a little bit higher as the result of some unusual circumstances where there have been economic situations where more than a market increase was required, either due to changes in job functions or a host of other economic concerns. So, I think it's very sector dependent, and so just, you need to be mindful of your sector and what's going on. Often there are deals to be done at amounts that are lower than this, but these is the cumulative average across the entire field.
And that's a good point. And one thing I was going to raise when we look a little bit more at the provinces is this isn't reflective of all provinces either. Specifically in Alberta, we're looking at an annual percentage of all collective agreements in the last years of being flat around 3%. And first year increase is slightly higher than that. So the numbers we're seeing in Alberta, where I am and where I practice, are much lower than this. And that has to do with the industries and the agreements that are coming due, like Ian mentioned. So this isn't representative of all industries. It's likely not even going to be representative of your industry. But what it's showing is still a stickiness with wage increase and a push for first year adjustments. And this just provides a little bit more detail showing that this is generally the same, although to different levels across all of the different industries, where we're seeing wage increases over the course of a collective agreement of between 3 and 4%, with first year increases being higher. Although, again, like Ian mentioned, these numbers are skewed by some very industry specific deals that are causing these numbers to be a little bit out of whack. But when we look here at Ontario, we talked about what the situation is in Alberta, where we're looking at about a median rate increase of around 3%. In Ontario right now, it is higher, and we're looking at a median rate increase of 3.9%, with a slight increase between the private and the public sectors. And I'll pass it over to Karine to talk about Quebec.
Yes. In terms of annual rate, we are about the same as Andrew. If we take away the exceptional deals, we looked at much more of an average of 3% per year in Quebec. Some of the statistics that I wanted to share with this audience is the fact that we still see in Quebec a raise of the work stoppages, so much more strike than lockout, obviously, but longer strikes, and we see here an average of 41 days of strikes or lockouts average. But again, it takes into account some very long working conflict in Quebec, but it does increase year after year, this trend. I do hope it's gonna turn the trend soon. And I wanted to just share again that in Quebec we are almost 40% unionized employer altogether.
And so one of the other trends, moving off from wages, that we want to talk about is the prevalence of AI and how AI is affecting bargaining proposals, and what we're seeing. Because, AI right now is obviously the boogeyman for a lot of different industries. There's still a lot of questions about how it's going to be used. But one of the things we do know is that unions are starting to raise issues relating to AI at the bargaining table. And, sophisticated unions are putting out policy statements. They're doing their research. They're taking steps to really understand how AI might affect their workforce, because this is what employers are doing. Employers generally, when it comes to technological changes, are far ahead of the unions. But the unions, or at least the sophisticated unions now, are really focusing on this issue. Now, it's a difficult issue because it's perceived as an existential threat to certain types of employers. And, we know that AI is becoming a thing in certain types of industries. Employers are using AI specifically in the logistics space to help with processing times and cutting costs. They're using it in the computer sciences space, where AI is starting to take the place of computer programmers or other types of engineers. It's being used in customer service spaces, where call centers are now being turned into AI chatbots or similar AI representatives that people can call in and actually talk to. And so we know that it's being used, and unions know it's being used, although nobody's exactly sure how it's going to affect the workplace going forward. So it's becoming a bargaining issue. And there's different types of ways that unions are thinking about this. There's going to be unions that we've seen proposals that are strongly against AI. And so what this means is unions have come with proposals to say things like, there could be no job losses or layoffs from the use of AI. Or similarly, it's looking for proposals that there could be no contracting out to technology companies that use AI. There There's also been proposals about duty to consult, that before using AI, that there has to be enhanced measures to discuss with the unions the potential repercussions of it. And also something called management by managers. There's been a push in some spaces to AI be more involved in human resources and performance review of employees, and unions are pushing back on that as well. So these are the types of things, that one approach that we're seeing at the bargaining table. Similarly, on the other side, we've seen more cautiously, not optimistic, but evolving approaches from certain unions. So some unions are saying, well, we should maybe treat this as part of standard technological change provisions of CBA. So there may be enhancements to layoffs or enhancements to severance amounts in the case of technological change, as well as certain notice provisions required to the union. There's also increased protection over privacy rights. Again, how are employers using AI data or personal information within the context of their workforce? And finally, some unions where they're seeing the likelihood of technological change are looking for more increased employer contributions to training funds, or to help pivot or transition employees to different types of work. And so the exact content and how this comes up depends on the specific union and the industry that you're in. But in almost all manufacturing, logistics, telecommunications bargaining that I've been involved in, AI has become an issue, and unions now want something about AI in those agreements, because they don't want to be caught out and they don't want to be seen as not having done their due diligence. And so it remains to be seen exactly how it's going to evolve, and exactly how it's going to manifest itself, if it does in your situation, is going to be very industry specific, but it's something to be prepared for when you go to the bargaining table, is something that might come up. And it's also something to have a good understanding of how you're using AI, how you think you're going to be using AI in the future, and what levers you're going to be able to use, and how you're going to work around ensuring that you're not unduly restricting yourself or your operations as you move forward. And the last thing we're seeing is, there's also still a continuing push, and we're going to talk more about different types of government intervention, but unions are lobbying governments to do something to help protect workers that they see as having insecure employment. So things like gig economy legislation, which just came into effect earlier this year in both British Columbia and Ontario. These types of things are going to be pushes that is another approach that we're seeing unions take to try to find ways to, protect their members or protect workers from technological changes. And then some other notable trends that have happened this year is, again, we're still seeing, we're all hoping that things were going to get better once inflation decreased. And I think we're going to continue to see that as long as inflation continues to decrease. We're getting to the point where new collective agreements have coming into force. And in the next year, hopefully we'll see wage increases at least stagnate, if not decrease. But it's going to depend on your industry and on your sector. The next is job security and changing economy. As we talked about tariffs, we have AI. There's a renewed focus on making sure that members have their jobs protected for unions. We continue to see issues with reaching settlements. Bargaining is going on for long periods of time. Parties aren't even getting to bargaining until closer to the deadline. I don't think I've had an agreement in the last year reached before the expiry of a collective agreement. It's taking a long time, and often in some sectors, it's taking years after the expiry of agreement to get to a deal. I think this has to do with a number of things, including specifically, pressure on unions to get a good deal, as well as, increased bargaining demands on everyone's time. And lastly, we are seeing cash is king. We've talked about the wage increases, first-year wage settlements. These are still the things that are getting deals done at the right time when the parties are ready to get there. And again, because of kind of this increase on wage increases and the time it's taking to get to deals, a lot of employers are trying to be more focused and more surgical when going into bargaining, to try to focus on what's truly important and try to get to a deal or to move on, because things are taking so much longer, that some employers are pushing back on the old strategy of putting everything on the table, to try to get what you want. Not to say that's not still a good strategy at the right time, but we're focused more on hard bargaining in some situations when we're trying to get to the final nuts and bolts. All right, so we're going to take a look at a few case studies, and we're going to start off with Karine, we'll talk about some in Quebec.
Thank you. So a good example, but not a good example, but a good example of what Andrew just said about not getting a deal before the expiration of the collective agreement is the STM, so the Regional Transit in Montreal, where, as you know, as much as all major larger cities, most people are transiting from home to work by either bus or subway. And when they do strike, it causes a lot of problems, because in Montreal, STM is considered service essential for a little bit of the time, but for most they can strike. So what happened is that there's numerous unionized units, but for the sake of this conference, we'll talk about the operators, drivers of the buses and the subway operators. This is one unit, a CSN unit, and there was also a maintenance, all the people in charge of the maintenance of the subways and the buses in a separate unit, both in negotiating at the same time. And after close to 80 sessions of collective bargaining, can you imagine sitting down 80 days to negotiate the renewal of a collective bargaining? It's very long negotiations, and the union strategy was to do some strikes in specific days last year in June, so June 2025, right at the end of the school year, the week of the exam of the kids, teenagers. No bus or subway were running out of the rush hours. So you had a few hours in the morning, few hours at the end of the day, and a few hours around midnight where you can have services. Other than that, it was no services at all. So this this was the union strategy in June for the maintenance. So because the maintenance were in strike, the subway and the buses were not running. And they did it again in October, and again, right in the Halloween weekend. And the subway and operators union unit started to do the same. And they just closed for the whole weekend at the end of the October, the Halloween weekend. So no services at all Saturday, all Sunday. It causes numerous of problem in the hospital, and a lot of people could not get to work, and they were spending their whole paycheck on transiting by Uber or taxi, and it was a huge problem. And it lasted half of the month of November. And meanwhile, if we step back, the bylaw 89 was adopted on May 30th, but was supposed to come into force only in November 30th. And I'll go through specifically what was the bylaw 89, now the law 14, later on this session. But most likely it was the power of the Minister of Labor to put an end to a strike and force parties to arbitration. And because there was a lot of heat on both unions and on the STM, the union decided to stop this nonsense strike at the middle of November. And an agreement was reached with the subway operators and drivers, but not with the maintenance employees. And the law just came into force the last Sunday. And just as a tip, unions, because most of them, I think 4 or 5 of them yesterday, December 1st, are challenging the law as it now in force. So there was a huge strike and work conflict within the STM and affecting the whole population of Montreal for at least mostly 6 months. And as you see on the slide, it was they put an end to that big problem at the middle of November because the minister was threatening to put the law in force 2 weeks before it was supposed to be enforced, just so it can stop, because it was just being such a chaos in Montreal. So I'll come back to the detail of this bylaw later on. Ian, back to you.
Yeah, I think that the case that is a really interesting example because it talks to us about government intervention in work stoppages. And I think that post 2015, when the Supreme Court of Canada recognized the right to collective bargaining as being constitutionally protected under the Charter, that we've seen sort of the expansion of that right in terms of how it's being applied. Governments don't want to touch it. They sort of have been staying away from intervening until more recently. And what we're seeing now is a move over the last several years where the government's recognizing it needs tools. It needs tools to put an end to or find alternate ways to resolve disputes in certain circumstances. And historically, there's been a very narrow window where this has been done where it's essential services, where the nature of the services are such that if they're withdrawn, it's going to represent a clear and immediate danger to the health and safety of the public. But what we're starting to see now is an evolution, I would say, in terms of governments wanting tools, creating tools that will allow it to intervene not only when it's dealing with a threat to health and safety, but when it's dealing with a threat to important things in people's lives, when it's being too disruptive to society or the Canadian economy as a whole, and that's a theme that you're going to see picked up later. I'm going to talk to you about a couple cases from that one Ontario and one national, but interesting activities with Ontario community colleges. This is a sector that exploded with the influx of international students in the last 10 to 15 years. Beautiful new campuses, big buildings, explosive growth. That's all come crashing down in the last few years, or in the last 18 months, with changes to the federal immigration regime and the restriction on the number of student visas that are being granted. Huge funding challenges in this sector. And so we're seeing this manifest itself in increasing tension at public sector and quasi-public sector bargaining tables. So at the Ontario community colleges, back in September, a big bargaining unit, 10,000 people. This is the full-time support staff working at 24 different colleges across the province. They went out on strike. What were the issues? Well, one of them was job security. And so as a result of the funding challenges that I've just mentioned, there's been massive job cuts. Okay, sort of doing it to survive. I think there's some concern in the sector about whether they're all going to actually make it through to the other side of this. And so huge concerns. So not only are they dealing with inflation, not only are they dealing with the need for some wage increases, but they're dealing with this funding challenge, and how are we going to ensure that the jobs that remain continue to be there going forward? So they were unable to resolve this. The strike went on for 5 weeks and interrupted at least the first half of the school term. And so, this is but one example. They were eventually able to get a deal in around mid-October after a several-day intensive mediation with arbitrator Bill Kaplan, who came in and was able to help them bridge the resolve. But I think this is a harbinger of things to come. I think we're going to continue, because it's not just the community colleges that are facing this issue. It's universities, it's other public institutions who are going to be facing, not only now, but even more so, I think, in the next couple of years, as the economy sort of settles out and we're pivoting towards infrastructure and we're refocusing on trade to parts of the world other than the United States, that we're going to see belt tightening that's going to have an effect on the public sector and lead to an increase in labor unrest. Hopefully not, but I think that may be what we're in for. So the quick word on the federal budget. There's a lot of things you can talk about in that, and the focus on infrastructure. But one of the things, it's been covered, but it hasn't got the same attention as some of the other things, is there's quite significant announcements about a redefining of the federal public sector. And we're already hearing stories at a certain federal tribunals and regimes and other sorts of bodies about incredible belt tightening and restraints. There's talks of it being the eliminations of many, many thousands of jobs in the federal public sector. And so this is a continuation of that trend. And so if any of you in the public or quasi-public sector are going into bargaining, this Ontario Community College case is something to kind of keep in mind, because it's going to be an extension of the sort of things that you may see at a bargaining table near you in the next round of bargaining and beyond. We don't really know what's going to happen with the federal public sector and how that's all going to materialize, but we're going to learn more about it in the coming next few months. So another labor dispute that received a lot of attention was Air Canada. Last year, we had a brief update for you on the negotiations that concluded in the fall of 2024 with the pilots union. This year, it was the flight attendants represented by CUPE. Again, a large bargaining unit, more than 10,000 people across Canada. After a contentious and lengthy set of negotiations that went on for over 9 months, the parties were unable to reach a settlement, and a strike commenced last August, Friday night, sort of Saturday morning, August 16th of 2025. Approximately 12 hours after the strike began, with upwards of 500,000 people stranded internationally and at various airports across the country and in various other circumstances, the government decided to intervene, and they issued a back-to-work order pursuant to Section 107 of the Canada Labour Code, which ended the strike, and which ordered any issues that remain unresolved at the bargaining table to be resolved through binding interest arbitration. So the process when an order under Section 107 is issued is, before it can be put in effect, it has to go to the Canada Industrial Relations Board, who has to review the referral. They have to determine the terms of the order that needs to be issued, deal with logistical challenges, and then they can go ahead and issue an order, and that's what actually puts people back to work. There was heated litigation over that, and in an attempt to forestall or delay things, the union, in that case CUPE, raised a number of very novel arguments, procedural challenges, and basically threw the kitchen sink at the CIRB in an attempt to forestall and or avoid the actual back-to-work order being issued. Air Canada was eventually successful in, or I guess the board made the determination that a back-to-work order was appropriate. They issued it at about 1:30 in the morning on the morning of August 17th, and people were supposed to get back to work at 12 p.m. on the Sunday, on the following day. But then in a rather unprecedented turn of events, the union decided they were not going to comply with the board order. And not only did they not comply, they made it public. The national president of the union on a stage at Pearson Airport in Toronto with TV cameras running, took a copy of the order and ripped it up quite theatrically on TV. And so that left us in a situation where orders are being issued by the federal board, they're not being respected, and it represented a new escalation in the situation. So further litigation continued before the Canada Industrial Relations Board. Late in the night of the August 17th and the early morning hours of August 18th, the Canada Industrial Relations Board issued an order declaring the work stoppage being engaged in by CUPE to be unlawful. And then shortly thereafter, a negotiated settlement was reached that brought an end to the work stoppage. Now, the settlement resolved all issues that were outstanding save for one, and that was wages. And there was an agreement reached between the parties to refer the wage settlement to interest arbitration. That interest arbitration process is currently ongoing. It hasn't concluded yet. And so more details about the end result of this will only be available once that process has concluded, which is likely to be sometime in the first several months of 2026. So national strikes, militancy of a sort that we had not seen before. Back to work orders have been issued in many different contexts before, but this is the first time where not only CUPE, but supported by the entire movement, union movement, said that this is not okay. We are not going to comply, and we're going to challenge and refuse to follow the directions and orders of the board. So an important litmus test. There's ongoing litigation about all the different aspects of this that is still ongoing. So it's a story whose conclusion is yet to be written, but interesting to see in terms of what this means for trends in the months and years ahead. I'm going to turn it over now to Andrew, who's going to talk about Life Labs.
Yeah. So just going to have two examples from, recent strikes out here out west. Not quite as dramatic as the Air Canada flight attendant strike, but what I think are kind of representative of what we've been seeing out this way. Because what we've had just in general, more work stoppages. There's a clear distinction between certain industries and certain workforces that are willing to go on strike, that are willing to test their leverage, versus others who are feeling more of a pinch and more of a squeeze and are not willing to go on strike. And we're seeing some of the larger wage settlements, not surprisingly, come from those industries where members are more willing to go on strike and where they have actual leverage in order to get the employer back to the table. And so one example of this was Life Labs, which for those of you who, I'm not sure if Life Labs is actually out east, but it's generally a Western Canadian company that runs diagnostic services. So it's where you go to get x-rays or ultrasounds and whatnot. And in February 2025, they started a fairly large rotating strike of 1,500 members. And the biggest issue that was going on was the wage disparity or wage parity between technicians and who work at Life Labs versus those who work in the public healthcare sector. And the strike lasted almost 10 weeks before a negotiated settlement was reached in May of this year. And this is one of those examples where we can see why out here, and it seems like across Canada, there has been a greater increase in private sector wages versus public sector. This is one of those ones, again, where workers were trying to increase their wages to be in line with their public sector colleagues. And ultimately, a deal was reached after mediation with wage proposals that increased between 4 and 5% over the 3-year term. And that's, as we discussed earlier, much higher than what we've seen generally out west, where we're still looking at wage increases to be around 3%, slightly higher in the first year. The Life Lab, this shows that there are certain industries where we are getting strikes, where there can be some pressure on employers due to the importance of the work. And Life Lab specifically is a very important service in British Columbia, in Alberta, for individuals to go get diagnostic testing in this kind of middle area between private and public health care. And kind of in the same vein, we have the example from Alberta of the Catholic Board of Education and the Catholic School District regarding their custodial workers and maintenance workers. And this was another strike that happened in February of last year with over 1,100 members of CUPE who represents custodial staff. And again, the biggest issue was a lack of recent wage increases. And so this was one of those examples where they hadn't had a wage increase in over the course of the last collective bargaining agreement because it was reached at the beginning of COVID. And so there was an attempt by the union to catch up and to make up the wages that they had lost over the last collective bargaining agreement, or at least what they perceived as lost wages as cost of living got so high. Again, strike here lasted for 3 weeks before a negotiated settlement was reached. And this was a 4-year agreement with an average increase of 3.6%. So again, slightly over what we've seen in Alberta, but a bargaining unit that had significant leverage to getting the deal done. My wife is a teacher, and I could tell you that it wasn't pleasant being in schools when custodial staff was out. And so there was obviously a good amount of they had their leverage, and there's good amount of incentive from the school boards to get that deal done. All right, and I'll turn it back over to Ian, who will talk more about government intervention.
Thanks, Andrew. So we've touched on this a little bit, but the theme that I like to sort of convey is that I think there really is a need on the part of governments across our country to find new ways of balancing what is obviously a very important right, that is the right to collectively bargain. It's a charter protected right, and balancing that right against globally the public interest. And so I think we've seen a pendulum swing where for many years, perhaps, the right to collectively bargain before it was enshrined and recognized as being charter protected was maybe treated as being less important. And then over time, it's getting more and more and more important. And then it's sort of gotten turbocharged in the last 10 years following the Supreme Court of Canada's Labour Trilogy in 2015. And sort of it got to the point where perhaps the pendulum had gone too far in the other direction. And so what we're seeing globally as a trend across the country is governments saying we need more tools in our toolbox. Okay. Historically, the main tool to deal with an out-of-control labor dispute was back-to-work legislation. But we've seen changes in the dynamics of politics in this country, both nationally and in many provincial legislatures, where almost all the political parties are trying to pitch themselves as pro-worker in one way or another. We've seen it federally. We've seen it provincially in Ontario, by way of example. The Doug Ford government did a very adroit job of attracting support from even the union movement as part of its last majority re-election campaign. And so we're seeing everybody pivot in that direction. There is a reluctance overall to use the slow and rather unwieldy back-to-work legislation tool to address these concerns. So in a world where Canada is now depended on by international partners to provide reliable trade, to provide reliable supplies of goods and services, to be a supply chain partner in a just-in-time delivery world, we're seeing that governments are saying we need to do more. There are situations where a dispute is going to be of such a nature that it creates such harm to the public, to the economy, to the larger public good, that we need to find ways not to crush or to completely disregard the right to collective bargain, but to allow for a resolution of disputes in a way other than a work stoppage or withdrawal of services. And so we're starting to see this evolution. Okay, and how it's manifested itself first, I think, is in the federal government over the last several years, and what they've been using is a section of the Canada Labour Code. Now, if you joined us for our federal sector update back in October, may have been early November, but recently, there's a much broader discussion about Section 107 of the Labor Code. It's a section that's been in the code for decades, but was rarely used until 2 years ago, really. And what it does is it gives the Minister of Labor the power to direct the board to do such things as the minister deems necessary. And then there's a laundry list of things, but basically to bring industrial peace or to facilitate the resolution of industrial conflict. And so, the debate and the discussion that's going on now and that has been going on is this a legislative instrument that should be used to end work stoppages, should be used to redirect matters to interest arbitration, in the absence of any sort of back to work legislation. And so this is the tool that exists in the code now. No government prior to June of 2024 had ever utilized it to try and end a work stoppage, but the federal government has now done it multiple times in the last 18 months. Okay, most recently with Air Canada in 2025. And so these orders have two key features. Most of them after WestJet, they actually explicitly say this strike is going to end, the lockout is going to end, and then it sets out how it is or what process requirements are going to follow next. In many of these cases listed on this slide, we've seen a referral to interest arbitration, but in the Canada Post case last December, it wasn't actually a referral to interest arbitration. Instead, there was a decision to appoint an industrial commissioner to come in and review the sector and provide recommendations. And while that process was undertaken, the strike that had been going on at that time for almost 6 weeks was put on hold. And so, it doesn't have to order interest arbitration. There's a broad remedy for what the minister can do or order in those circumstances. But what it does clearly do is put at least a temporary end to the work stoppage. So this is the tool that's at place now. Over the course of the last year, there's been a ton of litigation about this. First, people were challenging at the Canada Labor and Canada Industrial Relations Board. We've got a number of key decisions, including in the two cases referenced on this slide, which now make it clear that the Canada Industrial Relations Board doesn't have the power or authority to second guess the policy decision made by the government when it issues these referrals. And instead, if the unions want to challenge it and say it's an unfair restriction on their constitutional right to collectively bargain, on their constitutionally protected right to strike, they have to go to the federal court. Unions in this litigation also challenge the constitutionality of Section 107 on its face. Those challenges have been denied, at least for now. The key message that was through this whole litigation is that while the right to strike is very important and must be protected, it is not absolute and there are limits. And so what we're seeing now in the right here and now is there's legal challenges to all of the outstanding Sections 107 references currently before the federal court. They're being loosely case managed together. Hearings are expected to take place starting in 2026. I don't think we'll get any decisions immediately, but by the time we're back here next year, we may have an update for you. And this is going to be very important because it's going to signal what the scope of 107 is, the purposes for which it can be used. And it's an active question. The unions are very much saying you cannot use it for this purpose. That should be found to be improper. And the government is saying, no, it's proper and was utilized properly. So we're going to have to see what comes of this. But this is the one tool right now that is being used in the federal sector, but it's not the only tool. Okay. And so the recognition here that we need other ways of resolving disputes is now manifesting itself in other ways in certain provinces. And I'm going to turn it over to Andrew to talk a little bit more about the Alberta teachers' strike.
Exactly. And so we're seeing, obviously, governments try to look for tools in order to end these strikes to get individual workers back to work. And we've seen the return of back to work legislation. And we just saw this just last month in Alberta with the Alberta teacher strikes. So back to work legislation, those you might remember, was a frequent tool that was used to get individuals back to work until it was ruled in 2015, as Ian mentioned, that employees had a constitutionally protected right to strike. So as a result, back to work legislation at the current time is presumptively a breach of the charter. And so because it's presumptively a breach of the charter, the only way to pass back to work legislation is to invoke the notwithstanding clause. And in the context of back to work legislation, the notwithstanding clause has been used once before, and that was in 2022 in Ontario when there was similar in Ontario teacher strike. The Ontario government passed back to work legislation, invoked the notwithstanding clause, but in response, there was an enormous backlash. There was threats of a general strike. There were numerous complaints from labor organized behind that, much like how we just talked about in the Air Canada flight attendants situation. And there was a big political push to have that repealed. And that's what happened. It took about 5 days, but the Ontario government did repeal that legislation, and the parties moved to work through the differences through arbitration. But so far, the situation here has been a bit different. In this case, the teachers went on strike after a long bargaining, after bargaining for a long time, almost over 2 years. And on the 27th of October, they passed the back to work legislation. And this legislation was slightly different because it didn't just end the strike. It didn't just require teachers to return to work, but it actually imposed by statute a new collective agreement on substantially the same terms as a tentative agreement that had failed ratification just a few weeks further. So in this case, the bargaining committee for the Teachers Association reached a tentative deal and put it to the teachers, and the teachers voted it down almost over 90%. And so this legislation not only required teachers to go back to work, but imposed a contract on them. And the result's been slightly more muted in Alberta than it has been in Ontario. There has been a backlash, certainly. There has been, potential political damage to the government, but there has been the same push. And query why that might be. Certainly, there's always a difference between Ontario and Alberta politics in terms of the strength of the government here and the strength of the government in Ontario to a change in power. There's also, I don't want to say weaker, but not as strong a labor movement in Alberta. And so pushes for general strikes and pushes for collective action have seemed to fizzle. And so at this point, we're back to the normal constitutional challenges, and the ATA, the Teachers Association, is challenging the legislation before the court, and I believe they're going to have a hearing soon of whether or not they've sought an injunction of whether or not to stop that legislation, and then ultimately they're going to challenge it. And that will be interesting again to see, because in this case there is going to be a different question here, not just about the back to work legislation, but about the imposition of a new collective bargaining itself. So I'll pass it over to Karine to talk more about what's happening in Quebec.
Yes, coming to a province near you, we might see each other in the Supreme Court, all provinces together, fighting all those challenges from the union of these new tools. Because hello, Quebec, after 25 years of not having any piece of legislation in favor of employer, ta-da, we have this new Law 14 or Bill 89, who is clearly one of the newest tool to help employers after Port of Montreal strike, after school buses strike, after STM strike, and numerous others. Pressure was on the government to have this tool to consider economic and affecting population well-being and economics and all those criteria to create this new bill titled An Act to Give Greater Consideration to the Needs of the Population in the Event of a Strike of a Lockout. So needs of the population is something that will be, of course, interpreted by the court in the next year or two, and we'll have a better idea of what it takes to put pressure on the Ministry of Labor to act when a strike is taking too long. So it gives basically the government the ability to end the strike in the private sector and force parties into arbitration if work stoppage will impact services that, and quote, ensure the well-being of the population. So in the case of the STM that I mentioned earlier, it was clear to me that it was clearly an example of what would clearly fit into this well-being of the population for the government to intervene and stop the strike and force parties to arbitration. As you know, in most cases, employers want to go to arbitration because they know the union demands are just unreal, irrational, impossible. And we know that an arbitrator most likely will see the light, and but the union never wants to go to arbitration. So this piece of legislation can really help to have that arbitrator set up the working conditions when we know the employer is quite on market and reasonable. So that would be could be a very useful tool and maybe prevent some strikes, because maybe union will stay at the table longer instead of just going out because they know they will be forced to arbitration. So it could really create a new power of negotiation. Maybe I have my pink glasses here, but I like them, so I'll keep them. And the other piece of the legislation is the modification of essential services regime in Quebec. So earlier, almost no employer could qualify as essential services because it needed to create only health and safety problem to the population instead of the new definition of the second bullet here: services minimally required to prevent the population's social, economic, or environmental security for being disproportionately affected, in particular that of person in vulnerable situations. So this will clearly qualify much more employer to have some essential services given to the population instead of nothing. I can think of school buses that were on strike for so many months that I talked about a couple of years earlier in this conference that could have qualified, to my perspective, into that new essential services definition. So when you do have a possibility of serious or irreparable injury to the population, you can have the intervention of a conciliator, a mediator that has not been successful, and therefore the use of this tool to force arbitration and to force the employer and therefore the union to provide some services to the population. So again, this will be a very useful tool for Quebec employers. I cannot wait to give you some example next year. Hopefully, it won't be your company or employer being in the examples, but at least seeing the government be having the courage to use that tool and force some union to go back to work. Back to Ian, I think.
Yeah. So it's really interesting, this continuation of this trend. Additional tool. Now it's not only health and safety focused, it's economically focused. It's armed to the public focus. And so this is going to attract a lot of litigation. Right? Unions and the union movement as a whole is an incredibly, they fight with one another, of course, but they have common interests, and we see them banding together in a way that I wish the employer side would do more of. But to give you one example, so, Karine mentioned that many of the unions filed constitutional challenges the first day that law was in effect. We noted that all the other back to work tools that we referenced earlier in their slide, there's litigation all over the place on that. In some of those cases, I can tell you there's 17 18, 20 union interveners applying to participate in this. And there's maybe one from the employer side. So this is a movement on the union side where they see the gains over the last few years starting to sort of, there maybe be some limits on that, and they are doing all that they can to sort of continue to maximize the scope of the right to strike and the ability, because of the benefits it provides at the bargaining table, because of the additional scope it gives them to fight in appropriate circumstances. And so we're really in this battle for leverage, and it's playing out not only at the bargaining tables, but increasingly in the courtrooms, and in the legislative across the legislatures and the parliaments across Canada. So a little bit about maintenance of services. I'll be very brief here. Big changes in the federal sector this year. Now, maintenance of services is a provision under the Canada Labour Code, which is focused on maintaining safety essential services. The big changes to the process, the test didn't change, but what changed is that all the parties in the federal sector now have to reach an agreement on essential services within 15 days from the date notice to bargain is issued. You know, most rounds of bargaining I'm in, nobody's even met after 15 days. They're supposed to, under this new regime, have an agreement within 15 days. And then if they don't have an agreement, they got to go to the labor board and file an application. So we're seeing the start of a flood of cases to the Industrial Relations Board. The legislation sort of mandates that once that referral is made, the board has to come to a decision within 82 days. It's going to create a problem in terms of the number of cases that are being dealt with there. And so why is it causing this problem? Like, maintenance of services doesn't seem to come up very often. Well, it's because in the past, nobody really cared in a lot of different cases, either because they were going to shut down anyway, and so it didn't really make a sense, and they weren't in something that was life-threatening or dangerous. But in other situations, because if you had a small bargaining unit go out on strike, right, you could bring managers and other people in to sort of fill the gap, maybe not to resume normal operations, like that's probably unrealistic, but at least to make sure that things are protected, minimal things are done, property isn't damaged, equipment is properly monitored, safety checks are being completed, you know, little tasks are being performed so that there's not the danger. But with the replacement ban worker now in effect, that's not so easy to do. Right? So we've got this combination of now being forced to come to an agreement, now being forced to do this within 15 days, the additional tension of this replacement worker ban. Unions are not agreeing that anything's essential, and so it's a constant loggerheads. And so we're seeing it be a very challenging environment. The first decision on this new regime was issued by the federal board on November the 17th in a decision called AltaGas. There is one other case that we're expecting a decision on in about the next 2 weeks maybe, that's going to provide further guidance on how this is going to work out. But again, you know, for those of you in the federal sector, you need to be thinking about this issue before bargaining. It's going to affect your bargaining strategy. It's going to affect how things are going to play out. But for those outside the federal sector, this sort of process, if we see a world with continuing expansion of replacement worker bans, is likely coming to a province near you sometime soon again, hopefully not in the same form, which in my respectful submission is not a process that's beneficial to good labor relations for any side, any parties. But this concept of being forced to sort of confront these sort of difficult questions and potentially being required to do so right at the early bargaining. Like, it's tough to go in the early stages of bargaining and start with a fight. Never a good way to get off, right, on the right foot. But that seems to be what's happening. All right. So we're going to look ahead to 2026. A lot of these things are things that we've spoken about before, but we've put them in the slides to sort of group them together. We're going to have a couple of comments and then some additional tips and tricks at the end. So I think, Karine, I think it's over to you.
Yes. Okay, so even though inflation is less high, we're still in that bubble of union thinking, having the power of negotiation over the world, and still being very greedy and asking for a lot of raises in year 1 and even year 2 and 3. I don't know if they're gonna get a reality check soon. I hope for them, because we've seen a few company and shops closing the last couple of months in Quebec. We had a big announcement in Ontario yesterday. It's quite difficult to see some employer leaving or closing and negotiating those termination closing agreement. And so I do hope that union will get a heads up on what's going to happen if they continue to be unreasonable. They see the tariff and they see employers struggling with absolutely no adaptation to their strategy or talking to their members or the union table. So I do hope that this trend's gonna change in 2026 and have a better control on their members to control the demand for once and be more reasonable into what they are asking. One trend I think that was not there last year that I've seen, and I think my colleagues here have seen it as well. They do see some company closing. So instead of being more reasonable, they really want to get some job security provision in the collective bargaining. Oh my gosh, I don't know what happened to the slides. I touched nothing. Let's go back. Yes. Sorry, I don't know what happened. So we see some demands about getting a new protection about layoff, so a longer notice or indemnity to be given when a layoff is either temporary or permanent. We do see mass termination provision, closing of facility provision with, like, let's say 1 or 2 weeks per year of service, no maximum indemnity, not even a notice, but an indemnity, no matter what. So it can cost millions of dollars for a company just to close because of their new demands that I hope employer won't be forced to accept, because we haven't seen that in the past, having those very high job security demand. We've seen employers start to right-size their company and their workforce, and therefore reaction from the union with their demands. So all this to say that when you do prepare your negotiation, get ready to react to those and see how you can convince them to be reasonable on those. Back to you, Andrew.
That's right. So kind of on the other side of this, I mean, we have this new revised trend to job security, but we're also going to be seeing in a lot of industries some of the softer asks. Specifically, one of the things is, there's still a push to work-life balance. And, in my experience so far, it's been slightly less on the work because there's a push for job security. There's a push to maintaining employment or to maintain security around employment. But in the absence of wage increases in certain industries or significant wage increases, there's a push to, improving quality of life, improving, quote unquote balance, whatever it is. And whatever you may think of it, members are making it a priority for their unions. And, when we go into bargaining, one of the kind of tips is, dismissive responses usually aren't helpful. The be thankful for what you got, or look at, this is all we could do. The best we could do is, it kind of drives a wedge between at the bargaining table. And so one of the things we kind of look for is ways to leverage reasonable work-life balance proposals in exchange for items that provide you with greater flexibility. And again, we're seeing different issues come up, or different types of ask coming up, specifically in some bargaining I've been working on this idea of life side is, things like childcare subsidies or things like flexible hours, looking at additional benefits that could be provided, things that might come with some sort of cost, but are not necessarily hard monetary items. And in some circumstances, there are ways to look for those as gives that can show, like, look at this quality of life, look at this increase to quality of life, while trading those off for proposals that are going to give you greater flexibility. But don't be surprised if you see unions come to the table asking for more job security and less work, better work-life balance. And similarly, we still have the ongoing issue of remote work. And this is something that is, I think, going to continue to be a struggle. I think in the last year, we've seen certainly a decrease in remote work. We've seen a hard push to getting back to the office. And because of that, in unionized work environments, we're seeing still a continuous push by unions to secure some level of remote work in the industries where it makes sense, because that's something where they feel they can have some gains over private sector employers who, for Alberta, most workplaces in Alberta, at least, downtown Calgary, we're back to work in the office at minimum 3, in most cases 4 days back to the office with a lot of our large companies now. And so this is still a push, and still some unions are trying to hold on to remote work or hybrid work as a way to, again, increase value, increase work-life balance through bargaining.
So I'm going to pick up here. This is not a new trend, but it's one that we're really seeing entrenching ourselves. And this is an issue not only for employers, but for unions as well. The more you talk to the people you're negotiating with and union administrators and representatives at large, they are increasingly scared of this, and they're increasingly frustrated by this, because it makes their job so difficult to do. Whenever you're bargaining, you want to know and understand where the other side's coming from, what's motivating their behavior, and why it is they're doing what they're doing. But you also have to recognize the challenges they're facing, because there may be opportunities here to help and to make it a process that works for both parties. Whereas in the past, if a union came to, after long bargaining, a recommended settlement, the chances were really good that that was going to go through. But that's not the case anymore. We continue to see a large number of recommended settlements getting voted down. And so there is all manner of explanation for this. It's the perfect topic for a paper. I think the reasons are many. But I think it's certainly a trend that's gotten worse since the pandemic. The best description I've heard is that what we've seen is a loss of control over information. So much information is now out there on social media. People are getting their news and facts from different sources. They're no longer relying on the union to tell them about the deal or about what's good or about what's bad. The union has lost the control of information vis-a-vis its members. And that is coming back to create conspiracy theories is the wrong word, but distrust in the process, uncertainty in the process. It's the same phenomenon we're seeing with more media, sort of in a larger sense. People's views are being informed by all the various ways people get their news and information online these days, some reputable, but very many not reputable. And so you've got this mix where there's a loss of fundamental trust, and there's a loss of trust not only in the process, but in the players, the unions and the employers. Everybody's distrustful. And so as people are not willing to sort of say, okay, my union says it's a good deal, they've been fighting hard for me, I'm going to put my trust that they know what they're doing and I'm going to agree. They're saying, no. I want to have my own say. I want to impose my own views and my own view of the world and the facts and what's right and what's wrong and what's reasonable. And who knows what that's based on. So we're seeing that trend continue. And so you have to recognize that this is a realistic possibility. And I think that even if you don't want it to materialize, you have to sort of half expect it and come up with a plan, because it's going to affect how you approach things, okay? It's going to affect when and how you're going to make the decision to put that final and very best offer on the table. If you're worried that you're going to go into a ratification vote that you're not sure that's going to come out the right way, are you prepared to put it all out there, or do you need to hold something back for later? Are you in a situation where you have a relationship with the union that you can have a conversation with them about this issue and think about ways that you can reduce the risks of a bad outcome or control the results of a bad outcome? I've had situations where the union came up to me on the second day of bargaining and said, nothing we put to them on the first try is going to go through, so let's work together to figure this out. And we did. And we came up with a solution, and we came up with a process that resulted in a very good settlement being reached. It did take 2 votes, but we got it there, and it was all done in a controlled process that didn't result in a work stoppage. And I think the emphasis here is this is a problem that affects both parties. The unions are befuddled by this just as much as we are, and it's a difficult nut for them to crack. This may be something that you can work together with your partners on the union side of the table. Back channel communications and maintaining that line of communications, even when things are difficult, on process issues or things of this sort, are essential in my view to managing the negative and to maximizing the prospects of the positive outcomes that we're all hoping to obtain at the bargaining table. So, I think this is something you really need to think about and be mindful of as you work through the process. And it's a very complicated issue, and a lot of it depends on bargaining history, but it's a phenomenon of which everybody needs to be aware. Last comment I want to make before I turn it over for some concluding comments, then we'll deal with some questions, is about communications plan. It used to be, when I was taught, you don't talk about what's going on at the bargaining table. You don't issue statements. You sort of, the blithe, we bargain at the table. We don't bargain in public. We're not going to do that. And that's well and good and may still be the best course of action in many of the tables that you're at. But because of the same trends that are driving the distrust that I just mentioned a moment ago, we're seeing the need for employers in large and more complex negotiations to have a communication plan, especially if there's going to be a public element to it. If you're going to make it into the newspapers, if that's a real risk, you need to be thinking about this, because you can lose control of a negotiation. You can lose control of public interest. You can have things turn against you if you don't have the proper plan in place. Unions are much more sophisticated than they used to be on this topic. They're out there with social media campaigns, advertising campaigns in some instance. They're out there with and they've got good people doing it, very smart people, right? And they come up with the right soundbite, and all of a sudden the whole dynamics of a negotiation turn. It may not be what's going on in reality, but it's the spin. And so when you're going into these processes, you should at least pause each round of bargaining and think, do we need a communications plan and strategy? And if we do, think about the bullet points that are at the bottom of the screen. Having a communication and making a decision, do we need one or not, is just the first step. But, there's a difference between a good communication plan and a bad one. Okay. And so if you're going to go with a bad plan, it's better to do nothing. But a good communication plan is not easy. You have to plan in advance. You have to be very, very careful. Okay. When you're at the table and emotions are high, you want to be angry about all the wrongs that have been done to you by the other side. Okay. And especially when it's well deserved. But going negative rarely, if ever, works. You usually find a better end result if you can find a message that's digestible, that's simple, and that is positive. And be careful of spin. People are good at detecting. I was going to use I won't use a nonsense. I'll use, right? They can smell it and they don't like it. And so, be careful of being too cute with the spin. All right. Turn it over to Karine for some last tips, and then we'll look to any questions. If you do have questions, I'd encourage you to put them in the chat, and we will do our best to answer them.
Okay, so last tip to close a deal. We did that last year, trying to do it again. Front-end loading of contract is still a thing, but less so. So we see first year going down. That's a good news. avoid tabling false demands to create leverage. That does not help. I've seen some employers with creating demands to be able to exchange them. When negotiating, we see that as a more of a frustration because they ask question, why do you need this? Is there any example? And when we have none, we look as employers, we look bad, and so it's better to insist on what we need and not create demands for leverage. If you say you cannot afford the demand financially, consider sharing the costing data. So always help to show union how much cost their demands, and they can realize that it's obviously not possible. Next is important, no matter how contentious the relations are, try and keep a back channel line of communication open. Sometimes it's the HR person with the union press, or you with the union rep, or above union rep at the union federation. There's always someone we can try to connect and help with finding the right settlement. So always keep that in mind. Try to, before negotiation, as best as you can, to build or rebuild the trust. The union often start the negotiation by saying there's no trust. We wanted to show you right at the beginning that there's no trust, and so if when possible, try to create that trust or rebuild that trust as much as possible before the negotiation sessions. And if the relations are good, try to settle as much grievances prior negotiation to just remove that discussion from the table and not to prevent settlement just because there's so many grievances to negotiate. Maybe Ian and Andrew have other tips before we go to questions.
No, seeing that we only have 5 minutes left, Andrew, unless there was anything you wanted to jump in at, I was thinking maybe now might be a good time to talk about some questions, if that's okay.
I agree.
All right. Well, so if I ask you a question you don't like, just tell me so. But so the first question we have, Karine, is for you, and it's about Bill 89, and it's about, you mentioned that it's a private bill that's applicable to the private sector. Does any of it apply to the public or parapublic sectors, or is that dealt with separately?
It's dealt separately. As we know, the Quebec Labor Code has a whole section about the public and parapublic sectors, and all their essential services were covered by for those people, for those employers before. So the new bill is quite applicable only to private sectors. We might see some interpretation going down the road, but they were already kind of protected.
Okay. The next question has to do with the federal replacement worker ban and whether it was something that was widely accepted. I can handle that. The federal replacement worker ban is something that's been under discussion for decades. It's never been something that's been supported by any government before the Trudeau government. And it was a creature of the cooperation pact between the Liberal Trudeau government at the time and the NDP as part of the support mandate several years ago to keep the minority government in power. And so, having been part of meetings where we were sitting with the Minister of Labor, trying to convince them all the reasons this was not the best policy, we received effective admissions that nobody in the bureaucracy thought it was a good policy either, but it was a political directive that was non-negotiable. So it was never a situation that this was ever a good idea from a policy perspective in terms of maintaining balance between employers and employees. This was a political decision. And I think that's driven home by the fact that when the bill that included the federal replacement worker ban went to vote in Parliament, it was unanimously approved. I repeat that, unanimously approved. The Conservative Party was running to get out in front and telling how much they're pro-worker and how much they approve of all this. And the NDP was obviously supporting, and the Liberal government was supporting. Nobody wanted to say that they were anti-worker, which resulted, in my view, in the adoption of something that is not from a good policy perspective. So this would be an instance where I think politics overrode policy. So I hope that answers that question. The next question on the list is about bargaining strategy and open bargaining, i.e. allowing members in the room or disclosing proposals in real time, and whether that's helpful to get a good result and helpful to get ratification. I don't know if one of you guys wants to jump in on that one.
Never had that open bargaining before, so
Yeah,
I haven't seen it here.
it's something that we're starting to have happen out west. There is no, restriction on open bargaining. There are certain, in British Columbia specifically, there are circumstances where open bargaining is found to be inappropriate by the Labor Relations Board, but there's no kind of restriction or about who can be at the tables. What I'd say is I don't know if it would be helpful, and this is just me thinking, for ratification votes, because I'm not always sure that the people who attend open bargaining are the ones whose minds you need to change. Often open bargaining, when I see it from the unions, is a tool to kind of show the strength and the solidarity of the union, and they're there to back the union and be rah-rah. And, in some cases, an attempt to intimidate the employer at the bargaining table. So I wouldn't say that I would initially think that would be helpful for ratification. I think what would be more helpful, if you're going to be in those circumstances, like Ian mentioned, is to have a clear communications plan where you're going to be able to get the messages that you want to the other side. Again, understanding that you can't have direct dealing and being on side with any potential unfair labor practice complaints. But I think that is going to be a better tool than having people in an open bargaining table, where I think that you'll find the vast majority of people that attend are going to be the strong union supporters.
Two last quick questions before we wrap up. Are we seeing any trends in terms of the length of agreement? The only comment I would make on that is, whereas employers used to be motivated to try and get longer deals, and union would sometimes do it in exchange for a higher wage increase towards the end, we're seeing all parties now being a little bit more hesitant to go long, out of concern that we don't know what the status quo is going to be going forward. I'm seeing more 2 and 3 year deals as opposed to 5-year deals, but it is very industry specific, and sometimes coming to a financial resolve to address the press for an upfront increase requires you to maybe go 3 and 4. But I think that the general trend overall is slightly is in that direction. I don't know if the two of you have any different views on that.
No, I agree.
3 and 4 is pretty standard west these days.
Last question, then we'll wrap it up, is when we're dealing with difficulties with ratification and we're dealing with union members out there on social media trashing the deal and saying things that are unhelpful, the question is, the unions are often unwilling or unable to intervene. What strategies can employers use to deal with this? And this is back to the whole distrust issue that we talked about earlier. Whereas before, nobody would know about a deal. They'd go into the room, they'd have a vote. It would all be very controlled. The process has now much more chaotic. And so back to the communications plan and strategy. You're never going to be able to control every member's use of social media. And if you start to go out and chase them, you're going to be a problem. Have your own plan, have your own messaging, get out early if you're going to have an issue like this, so that when the cranks and the people that sort of are going to be out there anywhere get out there, you've already laid your stake to the middle ground, the common ground, the messaging that is going to win at the end of the day, as opposed to trying to respond and wheel back in something that may be out in left field.
Yeah, and on that point, social media is going to be the tool for unhappy members to use, and it's going to be something that you're not going to be able to stop. The union's not always going to be able to stop because it's just too prevalent, and chasing it down is going to just, in my view, tends to distract and can get you into back and forth fights that you don't need to be having.
We apologize. We've gone a minute and a half over, so we'll wrap up quickly with this. First, thank you. We really appreciate you being here with us today. We hope that you found at least some of what we had to say useful, and that we didn't put you to sleep. Couple of administrative notes. You're going to see the QR codes here for credits for Ontario, Quebec, and British Columbia. We've also added links to the audience chat, and again, we'd encourage you to fill out the survey. Our next seminar is December the 9th. Breaking up is hard to do. The challenges of just cause terminations. Well, that sounds like fun. So we'll hope to see you back next Tuesday. Thanks again, and be well. Take care.